We thought that we would never see a suit to compensate a tree, a suit whose claim in tort is pressed upon a mangled tree's behest, a tree whose battered trunk was pressed against a Chevy's crumpled crest, a tree that faces each new day with bark and limb in disarray, a tree that may forever bear a lasting need for tender care. Flora lovers though we three, we must uphold the court's decree. Affirmed. That, believe it or not, was the entire judgment in Fisher and Lowe, a case decided in the Michigan Appeals Court in the United States of America in 1983. Although there was a footnote with a little bit of legal detail. Unfortunately, most of the cases you will read during your time as a law student and as a lawyer will be neither so brief nor so entertaining as Fisher and Lowe. Unfortunately, that means you're going to need to learn how to read case reports effectively. G'day everyone, Anthony Marinak here, and this is the third and final video for Module 3 of our Introduction to Law. This is another one of those videos that's firmly focused on developing skills. Remember how in Module 2 we looked at how to effectively read legislation? Remember being surprised how much there was in a piece of legislation that you might otherwise have overlooked? Well, we're going to try to do the same sort of thing here, only with case law. Like legislation, case law follows a pretty clear pattern, and so our focus will be on learning those patterns, so you can start to read not only deeply, but efficiently. Efficiency is the byword when it comes to reading case law. One of the things that we academics see constantly in first year students is a tendency to spend far too much time reading cases at the expense of other more productive types of study. So wrapping your head around these skills will make a massive difference. Now, we're going to assume that you've already found your case because we went through that process in video 2 of this module. For this video, we're going to follow a single example, a famous case in the High Court of Australia from 1997 called Green and the Queen. This was the case that established what's called the gay panic defence or the homosexual panic defence, where a person might actually have a defence reducing murder to manslaughter if they panicked in fear and shock after being propositioned by a gay person. This was an intensely controversial case at the time, and now in most states, I believe in fact in all states, parliaments have responded to specifically remove the gay panic defence. We're going to look at two versions of this case. We will look at the version reporting on Ostley, and we'll also look at the version reported in the Commonwealth Law Reports, which you'll be able to find either in a database like Westlaw or on the shelves of a law library. The first thing you need to look at when you open a new case is which court made the decision. Now on Ostley, that's often self-evident because Ostley uses those medium neutral citations. However, for the written reports, it's crucial to check the reports. Some report series, including the Commonwealth Law Reports, contain judgments from a number of courts. So if you look back earlier than the 1980s, you'll find old Privy Council cases in the Commonwealth Law Reports, as well as High Court cases. So the first thing to do is identify the court. On Ostley, the court is the first thing we see after the citations, High Court of Australia. On the written report, pretty much the same. Up the top here it says High Court, and then over in the left marginal note here you can see HC of A, which of course is an abbreviation for High Court of Australia. Now we already know that most of the cases in the higher courts, and certainly in the courts of appeal and in the High Court, well, they don't start there. They're usually appeal cases. So the next thing we want to know is where this case was appealed from. On Ostley, we have to go hunting just a little bit, but here it is, on appeal from the Supreme Court of New South Wales. And here on the written report, the same information is right up front. Now that means that if we wanted to, we could search the databases and find that Supreme Court decision. And so we could really follow the history of this matter. So now we know what court we're dealing with, and where it was appealed from. That also tells us, of course, that we're dealing with New South Wales criminal law, which may in some ways be different to Queensland criminal law. That'll be something for us to bear in mind later. Next, we should look and see who the parties are. Now, the report will not only tell us the name of the party, but also their role in proceedings. So in this case, we see right up front on Ostley, Malcolm Thomas Green, appellant. So we know the name of the party, and we know that as the appellant, he's the one who has brought this matter to the High Court. Because this is a criminal proceeding, the other party is always going to be the Queen. In the reported case, we see the defendant's surname first up, but a little more digging around is required to get his full name. We can see it down here. Now, this is a fairly simple one, but it's not that unusual to find case names where a party might be a company or a government agency. You'll also come across a few Latin abbreviations in the party names. In particular, there are three that I want you to know. The first, ex parte, means that the matter was dealt with by the court even though only one of the parties was present. This sometimes happens, for instance, if the other party can't be found or if they refuse to come to court. The second, re, which you will sometimes see written as in re, means in the matter of. This is often used when the court is considering an application by a party, where there's not necessarily another side. A third one to know, ex rel, stands for ex relatione. This is used to indicate that one party is bringing an action on behalf of someone else. Now, this often happens when, due to the specific nature of the application or the statute, it's necessary for the Attorney General to actually bring the action, even though the cause of action is actually for the benefit of some private citizen or company. There are certain types of action that are reserved and only the Attorney General can bring them. Along with the parties, we can see the names of the barristers and solicitors who represented that party. On Ostley, it's right here under representation. There's a pattern to this representation. The first name mentioned, followed by SC or QC, is the senior counsel or Queen's Counsel who argued the case. Now, you really only see them in the higher appeal courts, and they usually appear in those matters with a junior barrister to assist them. So the junior barristers are listed next, Maloby for the appellant and Blackmore for the respondent. Now, as you'll learn in the fourth module, barristers are almost always instructed by a firm of solicitors who do almost all the legwork preparing for the case. In this case, we can see on Ostley that the appellant's solicitor was the Legal Aid Commission and the respondent's solicitor was the Directorate of Public Prosecutions. Now, all the same material is also in the printed report, but it's a little more difficult to find. If we look at the second page here, you can see that report includes a brief summary of the case and then an outline of the arguments that were made by each side, sometimes including key questions that were asked by the judges. At the start of the appellant's case, we can see the names of the two appellate barristers, and at the start of the respondent's case, we can see the names of the two respondent barristers. Now, for some strange customary reason that I don't particularly understand, in printed cases, the name of the firm of solicitors is printed at the very end. Okay, so now we know the court, we know the jurisdiction, we know the parties, and we know their representatives. The next thing we need to do is find out the final result. Now, that might seem like we're jumping the gun a little. It might seem like reading the end of the murder mystery before the beginning. Trust me, though, the reasons will become clear. On Ostley, the outcome is right up front. The appeal was allowed, which means the appeal was successful. And the court has ordered that the conviction should be quashed or set aside and a new trial should be held. In the printed report, the order is listed at the very end. So now we know the outcome. The next thing to do is to look at the whole court and see how the outcome came about. You see, sometimes all 7 judges on the High Court will sit on a matter, and sometimes they'll all join to make one unanimous judgment. Sometimes they might arrive at the same conclusion, but they might get there by slightly different reasoning, or one or more of them may want to write their own judgment. And sometimes one or more of the judges might disagree with the opinion of the majority, and they might write what's called a judgment in dissent. So we need to go through now and work out how many judgments there are and whether any of them are in dissent. Now, on Ostley, right up the top here, we can see the judges who sat on the case. Chief Justice Brennan, Justices Toohey, McHugh, Gummow and Kirby. So there were 5 sitting for this particular case. Scrolling down to the start of the judgments, we can see that Chief Justice Brennan has written a judgment of his own. And if we scroll to the end of his judgment, we can see that he says the appeal must be allowed and a new trial ordered. Immediately after that, we can see that Justice Toohey has written a solo judgment, and Justice Toohey has also said the appeal must be allowed and a new trial ordered. Next, Justice McHugh has written his own judgment. Scrolling down, we find that he too said the appeal must be allowed and a new trial ordered. So that's 3 out of 3 agreeing with the appeal. The next one is Justice Gummow writing on his own. So now we know this is one of those cases where everyone has written their own judgment. We scroll down Justice Gummow's decision and we find that he is in dissent. He says the appeal should be dismissed. Finally, we have Justice Kirby, who's known as the Great Dissenter and who has also written in dissent. So now we know this was a bench constituted by 5 judges and it was a 3-2 split. 3 judges allowed the appeal and 2 judges would have dismissed the appeal. Why is this important? Well, the precedent established by a case will only ever be established from one of the majority judgments. There is such a thing as a persuasive dissent, and it might be that in the fullness of history, later courts might decide that the dissenting judgment was powerful enough that it should be adopted. But generally speaking, the majority judgments are where we must go to find the law. Problem is, in this case, there are 3 majority judgments. Well, here's where you get to be a real law student and read your eyeballs off, because there's no shortcut here. You have to become familiar with all 3. How do we go about this? Well, fortunately, there are some tricks I can teach you. The first thing to do is look at what's called the headnote. There's a headnote in both the Ostley and the reported version of the case. The headnote tells us in the briefest possible form what the different issues discussed in the case were. So it's criminal law, a murder case, defensive provocation has been used. Now you don't know at this moment, you don't need to, but the defensive provocation includes what's called an objective test, where we ask what an ordinary person in the position of the accused would do. It says here, in this case, should an ordinary person be assumed to be someone with a family history of sexual abuse? Should the jury be told that this family history might affect the way the defendant reacted when the victim propositioned him? Does it matter that the victim was gay? There's the whole case, wrapped up in those few lines. If that's not enough for you, the reported version of the case also includes a summary of the case written in normal prose. So now we know what the story is going to be and how it's going to be decided. That ought to make things much easier when we read each judgment. Never be tempted just to read the headnote. It is necessary to then go and read each judgment. I'm going to walk you through the judgment of Justice McHugh. Now, once I've done that, I would suggest that as a learning exercise, you also go through the judgments of the other majority judges, Chief Justice Brennan and Justice Toohey. Make sure you also read Justice Kirby's dissent, though, because it's so beautifully written and because it sets out the rationale which later caused the various parliaments to do away with this gay panic defence. Now to Justice McHugh. Judges tend to follow a bit of a pattern when it comes to their judgments. If you start by looking for the elements of that pattern, then you'll find the cases making a lot more sense very quickly, much more so than if you just try to read them like a novel. Bear in mind that not all judges do things in the same order, so you might need to hunt around, but all of these elements will usually be in there. The first thing to look for is their outline of the facts. This is sometimes very brief and sometimes very long indeed, depending on how complicated the facts are, and depending on whether the facts were really the source of dispute in the case. In this case, Justice McHugh summarises the general facts of the case, and then he really zeroes in on the facts and the evidence which are most important to his judgment. It's always important to thoroughly read those facts because even though the court is establishing new laws or interpretation, they do this on the basis of the very specific facts before the court. And so in this case, we learn that the accused and the deceased were friends, that the accused was staying the night at the home of the deceased, and that they were to be sleeping in separate bedrooms. We learn that the deceased came into the bedroom where the accused was in bed and crawled into bed with him and began in essence an attempt to seduce him. He reacted by saying no, and then when things went further, he reacted violently. The violence peaked when he got hold of a nearby pair of scissors and began stabbing the deceased with the scissors. The defendant claims that from the moment he commenced his violent reaction, the picture in his mind was not the picture of the deceased trying to seduce him, but rather the picture of his own father standing over and sexually abusing his two sisters. He says that he then essentially lost his cool, and this resulted in the death of the deceased. So those are the facts. The second thing to look for is the actual rule involved. In this case, the relevant rule was Section 23 of the New South Wales Crimes Act. And Justice McHugh has very conveniently reproduced the contents of that section right here in his judgment. Have a read of that section. In essence, we can reduce that section to say, first, if someone kills someone else but they're provoked into doing it, well then it may be that they should be convicted of manslaughter rather than murder, and that'll result in a much shorter sentence. To work out whether they were sufficiently provoked, we asked two questions. First, did the conduct of the deceased result in the loss of the defendant's self-control? And second, could an ordinary person in the position of the defendant also have lost self-control to the point of killing? These are what we call subjective and objective tests. The subjective test says, what did the defendant actually do? An objective test says, what would a reasonable person have done? Okay, so now we've got a sense of the relevant law. You don't need to suddenly become an expert on homicide, but you may have a sense of the relevant law. The next thing the court will do in an appeal case like this is to look at the procedural history of the matter. Remember that matters like this don't start in the higher court. So it makes sense for the judge to go through those lower court decisions and say, what's actually being appealed in this case? So first, Justice McHugh talks about what happened in the original trial. Now, appeal court judges are often very respectful of what those first instance judges rule, because the first instance judge has one massive advantage that none of the appeal judges get. They get the chance to actually see the witnesses and the defendant in their court giving their evidence. All the appeal courts get is a transcript of that evidence. Now that seems a bit dumb to me, and perhaps one day these things will be video recorded and the recordings made available to the appeal court, but at present that doesn't happen. In any event, Justice McHugh concentrates on the matter which was appealed. That is, the first instance judge's summing up of the case for the jury. You can read the judgment and see exactly what the first instance judge said, But in essence, the judge made 2 points to the jury. First, the issue of provocation had been raised, and so it was for the prosecution to prove to the jury beyond reasonable doubt that the murder had not happened as a result of the defendant losing self-control at the conduct of the deceased in trying to seduce him. And second, that when the jury was considering whether an ordinary person in the position of the defendant would have reacted so violently, they must not consider his family history of sexual abuse. Again, don't worry so much about the law, but you can see in Justice McHugh's judgment there that he has outlined that those are the two things from the first instance judge that was being appealed. Next, Justice McHugh looks at what happened in the Court of Appeal. He identifies that there were 6 grounds of appeal raised before the Court of Appeal, and he goes through what happened in relation to each of them. He then considers which of those are relevant to the current appeal, and this is where we get to the real nitty-gritty of the case. Before we look at that nitty-gritty though, I want to introduce you to 2 Latin terms, ratio decidendi and obiter dictum. The ratio decidendi, or rationale for the decision, is the actual basis for the court decision. In a decision of 40 or 50 pages length, the ratio decidendi, which is often just called the ratio, might be just a sentence or a paragraph. It's the absolute heart, the fundamental basis of the reasoning before the court. Now, obiter dictum, or things said in passing, is everything in the judgment which is not part of the ratio decidendi. Obiter dictum is often just called obiter. Why does this matter? Well, the only part of the judgment which is actually binding on the lower courts is the ratio decidendi. So finding the ratio in a case is a massive skill. We're going to do that right now. Let's get back to Green and the Queen. In Justice McHugh's opinion, this whole appeal comes down to 2 key points. First, he looks at what were the second and third grounds of appeal before the Court of Appeal. In essence, the judge in the original trial said the defendant's special sensitivity to sexual matters arising from the abuse of his sisters was not admissible, and as a result, the jury couldn't consider it. The Court of Appeal, however, didn't agree. They found that it was admissible, and the jury should have considered it in relation to the question of whether the accused was actually provoked. I mean, a person who has a special sensitivity might well be provoked in circumstances where a person without that sensitivity might laugh off a provocation or handle it more diplomatically. And we can see Justice McHugh's ratio decidendi on this point. Here he writes, "The errors in question here led to the trial being fundamentally flawed. The accused's real case on provocation was never left to the jury. That being so, it is irrelevant that the majority judges of the Court of Criminal Appeal thought the defence of provocation would be rejected by a reasonable jury." Once you read everything else relating to that issue, it really all comes down to that conclusion. The original judge's incorrect ruling meant that the defendant was not able to put his case to the jury, so he didn't get a fair trial, so he should have another. Then Justice McHugh goes to the second issue, under the heading, the second day ruling. I'm not going to go through that in detail here, or else this video will go on forever, but on that issue he also finds that the accused did not get a fair trial. And so you can see that then he comes to his order. So if you think about it, it's not a matter of reading the judgment like a novel. It's a matter of looking through and following those steps in the logic to see and identify that ratio decidendi, that reason for judgment. That's the thing that you're really looking for. Now, what I'd really like you to do at this point is pause this video and have a look at Chief Justice Brennan's judgment. Follow the same sort of pattern that I've suggested and see if you can identify all the bits, including the ratio decidendi. I'll set out the steps on the screen in just a moment. Have a go at that and then come back to this video. Now, there are a couple of other things that I want you to look for when you're reading a case. First, don't forget to have at least a look at the dissenting judgments. In this case, Justice Kirby's dissenting judgment is absolutely crackerjack. Anything written by Justice Kirby is going to be good. I mean, he's possibly the most spectacular legal author we've ever had on the bench. But listen to this. In my view, the ordinary person in Australian society today is not so homophobic as to respond to a non-violent sexual advance by a homosexual person as to form an intent to kill or inflict grievous bodily harm. He or she might, depending on the circumstances, be embarrassed, treated as at first as a bad joke, be hurt, insulted. He or she might react with the strong language of protest, might use as much physical force as was necessary to effect an escape, and where absolutely necessary, well, they might even assault the persistent perpetrator to secure escape. But the notion that an ordinary 22-year-old male, the age of the accused, in Australia today would so lose self-control as to form an intent to kill or grievously injure the deceased because of a non-violent sexual advance by a homosexual person is unconvincing. It should not be accepted by this court as an objective standard applicable in contemporary Australia. Well, snap. I mean, Justice Kirby was in dissent in this particular case, but the parliaments of the various states of Australia ultimately saw it his way, and defendants can no longer claim provocation merely because they get hit on by a person of the same gender. One last thing, because, well, we've covered a lot of ground in this video. One thing you'll need to do before you close out your reading of a case is to check and see whether other cases have considered this case. And you'll also quite often want to see what cases were considered by the judges who wrote this particular judgment. So you can sort of see where this case falls in the string of authorities, in the string of precedents. There are a couple of ways to do this. The first and easiest is that in many cases, although for some reason not this one, they actually have a section up near the headnote which lists the cases cited in the case. So that's obviously a great start. But what do we do in cases like this one, where the cases aren't listed? Well, do you remember when I talked about legislation in Module 2, I talked about the process of noting up the legislation? Well, you can do exactly the same thing with cases, but using a very nifty and free database called LawCite. We go up here towards the top of the case report on Austlii and click on LawCite Records, and up pops a list of the cases which this case referred to and cases which came along later and referred to this one, as well as things like reports and scholarly articles. I mean, as you can see, this particular case got a lot of attention. Over on the right, you can see what's called a citation index. Now, that tells you a bit about the cases that have cited our case. As you can see, many of them have no stars at all, whereas others get 5 stars, meaning that they themselves have been cited hundreds of times. So obviously, if you wanted to look into what's happened further in this area of law, those are the ones that you would start with. So there you go. Now you know not only how to read legislation thoroughly and deeply, you also know how to read cases thoroughly and deeply. Obviously, on your way through law school, you're going to come into contact with hundreds of cases. You're not going to read them all to this level of depth. But the key cases, the ones your lecturers seem to focus on, don't just settle for reading what someone else says about them in a textbook. Find the case and have a look for yourself. I promise it'll be worth it. So here we are at the end of Module 3. In this module, we learned about the court system, concentrating on Australia, but also looking at the UK and the USA. We learned about the court hierarchy and how that hierarchy allows people to appeal cases upwards, but also how the rulings of those courts bind the courts lower in the hierarchy. That provides the basis of our system of stare decisis, or the doctrine of precedent. In the second video, we unlocked the mysterious code of legal citations and showed you how each citation gives you exactly the information that you need to find any case, either online or on a bookshelf. And finally, in this video, we looked at how to read the case once you find it. At this point, we've covered off on both of the primary sources of law in Australia, legislation and case law. So you've got all the skills you need to find the law, to read it, and to understand it. But that's only the beginning. The real lawyering happens when you take all of that learning and apply it to a real-world situation. Remember way back in Module 1 when I talked about lawyers being problem solvers? Well, Module 4 is where that comes to life. It's the key module in the whole course, where you learn to reason like a lawyer and to argue like a lawyer. See you there.